Admitting all. Y'all.
Good morning.
Morning. Is this everybody?
Yes, I believe so.
Okay. Let's see what this is 003-2059-2020. John Hurt and Leslie Hurt versus Amalendu Ashwami and Harsha Ashwami. Probably I'll start with who you are and who you represent.
Roy Reeves for John and Leslie Hurt.
Your Honor, Caroline Wright for Amalendu and Harsha Goswami.
I've read the motion. I'm assuming there still is no response to the discovery.
Your Honor, actually, yesterday evening and as well as this morning, Mr. Reeves supplemented and provided responses, which I have briefly looked through. There are still a number of issues which I would like to bring before the court. But yes, there has been some supplementation as of last night and this morning.
Okay. What did you want to bring up?
A number of things. First and foremost, Your Honor, the responses contain a number of objections. It's our position that these objections were waived several months ago when plaintiff failed to timely respond to the discovery.
Okay, I agree with you. If they weren't responded to within 30 days, they're waived.
The second issue, Your Honor, is the request for disclosure responses indicate $7,000 to $8,000 in repair/remediation costs. As a reminder, this is a water damage mold remediation case in a residential home. And it's clear we're still missing several documents based on that. We don't have any invoices or receipts for repairs or work that's been performed on the home. And based on the documents which were produced, which provides a breakdown of those costs, these documents appear to exist. If they don't, the plaintiff needs to respond none. As it stands, they responded see attached, and those documents are not contained in what was produced yesterday evening and this morning.
Okay.
Your Honor, if may I address that one? I apologize to the court. I'm looking here. I have a folder and it is just called repair cost. And those were, I reproduced the documents that were in that. I will be happy to sit down with my client and say, hey, if there's more, I need more. I don't do math. So I apologize to opposing counsel. I'm in a hurry last night and I'm going, it says repair cost. So zip attach.
Okay. What we'll do is I'll order you to provide full responses within 10 days. That should get it all worked out.
And Your Honor, there are a few other issues as well that if I can briefly get to. There has been nothing produced which supports the claim for attorney's fees, although according to the request for disclosure, plaintiff is seeking over $14,000 for attorney's fees. Several of the interrogatory responses, specifically 4 and 19, refer to the Texas Property Code and the Government Code, but they don't contain any specific subsection. I don't think it's our job to, or that we should have to guess as to which subsection they're alleging my clients have violated. I think they need to be more specific.
And I would disagree with that, Your Honor. It is spelled out in our pleadings. It is not my job to go educate opposing counsel. If I've spelled out in the pleadings in full compliance with rules 278 and 279, I've set them out correctly, then I don't understand why I have to do their legal research.
Well,
I agree with
that partially. I mean, if the pleadings don't spell it out, you can file special exceptions to the pleadings to get them to be more specific on what they're arguing about. But that's more of a pleadings issue rather than.
Well, Your Honor, that actually brings me to my next point, which is several of the interrogatories point solely to the pleadings. And I think that's not sufficient. The pleadings and the petition on file is not verified. That's not a proper way to get around the rules of discovery. I think they still need to provide this information in verified form. I don't think they can just point to the petition as a means of bypassing rules of civil procedure. And that's the case for interrogatory 5, 6, and 7.
Well, I don't have the responses in front of me because
Well, for example, interrogatory 6 asks specifically for the date that the plaintiffs first discovered the mold issues.
okay.
And they just say the information is sought out in the petition. For example, the petition doesn't contain any date.
Okay. Well,
And even if it did, that's not sufficient when it's not in verified form.
what I'll do is order you to give complete answers to the interrogatories within 10 days. And
Sure.
if it's not complete, then we'll deal with it because that's a pretty simple answer. Or question is what date? There's a date that should be answered.
In other words, they are not to refer solely to the petition.
Right.
The other thing, just for plaintiff's referral as well, interrogatories 8, 18, and 20, those are not sufficiently responded to. For example, they didn't provide any dates, which the question specifically asks for. And that's sort of critical in a case like this. So we would ask that they amend that as well.
Yeah. Give the best dates you can give on each of those. And yeah, y'all haven't done depositions yet?
No, sir.
Okay. Some of those are probably better left to depositions where you can actually try and figure it out. But I think you're entitled to know what dates certain things happen. So anything else?
That's all I have, Your Honor.
Okay.
And just to be clear with regard to the invoices and repairs, was the court in agreement that they need to supplement either with those documents or change their response to none? So it's clear to us that we're not going to be getting those.
Yeah.
In other words, we just need to know if if work has been performed, we need to know how much that costs. Or if it hasn't been performed, we need to know that as well.
Exactly. And what we'll do is have you comply within 10 days to, supplement your discovery and comply within 10 days and give full and complete answers to all the questions that were asked, and don't just refer to the pleadings because I don't know what the pleadings have in them. Apparently they don't have the dates and stuff. So
Yes, sir.
just get with your client and whatever they got, turn it over, and then we'll go from there. Does that make sense?
Sure.
And is that also the case for the attorney's fees documents?
Yeah. If
We can produce invoices on those, Your Honor. I don't know how to get them out of the system. I know how to look where it says the total the client has been billed to date. That's the only thing I know to do with that, but I can get
the problem with like attorney's fees and stuff, if you don't produce them, you can't claim them.
Yes, sir.
So that's kind of a reason you'd want to produce them. So, okay.
Your Honor, I will draft that order accordingly, and Mr. Reeves, I will send it to you. I don't have that drafted because we just got all the discoveries last night and this morning, but I'll get that over to you, Mr. Reeves, for you to approve as well, and then I'll send it to the court.
I'll
Yes.
sign it when I see it.
And Your Honor, a housekeeping measure. I know there was an unopposed motion for continuance filed. I apologize. I don't know if we've actually, has the court granted that? Did you need anything from me to confirm it's unopposed? That's a minor housekeeping
I
matter.
did grant. I signed it.
Okay. I just want to make sure I was not a holdup on that.
Yeah, signed July 6th. I moved the jury trial to the week of November 15th.
November 15th.
Formal pretrial on November 11th.
Thank you, Your Honor.
Hopefully we'll have juries by then.
I just want to make sure it wasn't me holding things up. So while I had everybody here.
It's signed and done. So, all right. Anything else?
No, Your Honor. Thank you.
Okay. I will see y'all soon.
Thank you, sir.